Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 5 and 6 on the speed of 90 words per minute. Start. In view of the finding arrived at by the learned arbitral tribunal that the termination of the contract was illegal and without following due procedure as required under the contract, and in view of allowing the claims of the claimants partly, the arbitral tribunal dismissed the counter claims submitted by the petitioners. The award declared by the learned arbitral tribunal has been confirmed by the first appellate court in a proceeding under Section 34 of the Arbitration Act. The same has been further confirmed by the High Court by the impugned judgment and order in an appeal under Section 37 of the Arbitration Act. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court dismissing the appeal under Section 37 of the Arbitration Act and consequently confirming the award passed by the learned arbitral tribunal, the original respondents, state and others have preferred the present special leave petition. Learned counsel appearing on behalf of the petitioners has vehemently submitted that the High Court has materially erred in dismissing the appeal under Section 37 of the Arbitration Act and has materially erred in not properly appreciating the fact that the arbitral award was passed contrary to the materials on record. It is vehemently submitted by the learned counsel appearing on behalf of the petitioners that the High Court has materially erred in not properly considering that the suspension under the agreement was not the suspension of work per se, rather was suspension of all payments to the consultants, and therefore there was no question of dilution or go by of the suspension letter. It is further submitted that the High Court has not properly appreciated or considered the scheme of the contract. It is submitted that in case of non-performance of the contract satisfactorily, the first step was suspension of payment, and if the failure in performance is not remedied, then the consequence which follows is the next step, that being notice of termination by issuing 30 days notice. It is submitted that therefore the High Court has materially erred in confirming the finding recorded by the learned arbitral tribunal that the termination of the contract was illegal and without following due procedure as required under the contract. While opposing the present special leave petition, learned counsel appearing on behalf of the respondents, original claimants, has vehemently submitted that there are concurrent findings of fact recorded by all the courts below on the illegal termination of the contract. It is submitted that on appreciation of evidence, the learned arbitral tribunal gave the specific findings by giving cogent reasons that the termination of the contract was illegal and without following due procedure as required under the contract. It is submitted that once the findings recorded by the learned arbitral tribunal are on appreciation of evidence and considering the materials on record, the same is rightly not interfered with by the courts below in the proceedings under Section 34 and 37 of the Arbitration Act. We thus hold that when the corporation takes step for recovery of the amount by resorting to the provisions of Section 29 of the Act, the limitation period for recovery of the balance amount would start only after adjusting the proceeds from the sale of assets of the industrial concern, as the corporation would be in a position to know as to whether there is a shortfall or there is excess amount realized only after the sale of the mortgage or hypothecated assets. This is clear from the language of subsection 1 of section 29, which makes the position clear that where any industrial concern which is under a liability to the financial corporation under an agreement makes any default in repayment of any loan or advance or any installment thereof or in meeting its obligations in relation to any guarantee given by the corporation or otherwise fails to comply with the terms of its agreement with the financial corporation, the financial corporation shall have the right to take over the management or possession or both of the industrial concern, as well as the right to transfer by way of lease or sale and realize the property pledged, mortgaged, hypothecated or assigned to the financial corporation. Even otherwise, it must be mentioned that the division bench was in error in stating that the right to personally recover the balance terminates after the expiry of 3 years. It must be remembered that the question of recovery of balance will only arise after the remedy in respect of the mortgage deed has first been exhaustive. If a mortgage suit was to be filed, the period of limitation would be 12 years. In such a suit, a prayer can also be made for a personal decree on the sale proceeds being insufficient. It is thus clear that merely because the corporation acted under Section 29 of the State Financial Corporation Act did not mean that the contract of indemnity came to an end. Section 29 merely enabled the corporation to take possession and sell the assets for recovery of the dues under the main contract. It may be that only the corporation taking action under Section 29 and on their taking possession they became deemed owners. The right to claim for the balance arose under the contract of indemnity only when the sale proceeds were found to be insufficient. The right to sue on the contract of indemnity arose after the assets were sold. The present case would fall under Article 55 of the Limitation Act 1963, which corresponds to old Articles 115 and 116 of the Old Limitation Act 1908. The right to sue on a contract of indemnity or guarantee would arise when the contract is broken. Therefore, the period of limitation is to be counted from the date when the assets of the company were sold and not when the recall notice was given. The upshot of the aforesaid discussion is to hold that the present appeal is bereft of any merits. Upholding the judgment of the High Court, we dismiss the instant appeal.